Well, good morning, Judge. It is awfully nice to meet you, and thank you for taking the time to talk to us about your practice, especially your Title IX work, which I find so interesting. And I think I would like to start by having you talk to us today about your overall approach to ADR.
Well, of course, there's a big difference between mediation and arbitration, which are the two major parts of ADR. But both require certain foundations that are the same. Fairness, objectivity, preparation, and the ability to listen and analyze, and common sense in terms of good judgment about what the problems are, what the needs are of the individual parties that you're working with. In mediation, my approach is also to stick with it. In other words, you don't give up. You really keep working with the parties in order to get them to a resolution that they can live with. They're not always happy, but it's something that they can live with, and you work hard at that. So, for example, if I don't get it done that day, I keep working until I do get it done. And sometimes I've even worked till 2:30 in the morning with parties to get them to a resolution. And I think that in the end, that piece is greatly appreciated.
As I mentioned, your Title IX work, you're so good at it. And I'm just curious from a background perspective, what decided you to get involved in Title IX work, becoming a hearing officer for higher education? What brought you in that direction?
Well, it more or less was thrust upon me because I got a call years ago from a trustee at Swarthmore College asking if I could come become a hearing officer for them, where they had students who were in a dispute. One accused another, and they had a policy to have hearings, and they needed someone who had a lot of experience in understanding sexual assault and credibility questions. And of course, I had been a trial judge for many years, handling sexual assault cases when I had been a trial judge. And so this was something that I had familiarity with and understood. And so I began to handle their cases, and that's really how it happened. And then, of course, I became an advisor to the ALI, the American Law Institute's campus sexual assault program. And well, not program really, it's developing a code for universities in the area of sexual assault. And so I just started, it just kept rolling along, so to speak, in terms of working with a variety of institutions, each with their own culture. But it's really great trying to help these institutions navigate through a tremendously difficult area. And so that's how I got interested, and why my expertise and experience has been helpful, I think, to them.
Great. Do you have any thoughts as to why it's so important for higher education institutions to enlist someone like you, a third-party neutral, to help them resolve Title IX disputes as to handling them on their own, for example?
You know, as a neutral, although I'm not necessarily particularly familiar with the school's culture, Nevertheless, my experience in the area of sexual assault, my experience, and at this point, my experience in working in Title IX is, I think, lends itself to an understanding of the needs of the students, the problems that the students are dealing with in coming before a neutral individual who's making a decision regarding what actually happened and whether, and the credibility issues, the consent issues, understanding all that without a bias at all. Just totally an objective, no interest other than helping the students and the school resolve a very difficult issue. And sometimes it does require an understanding that one person has really hurt another. Sometimes it isn't that. And you just have to know how to separate what really, and figure out what really happened and how to move on, how to get the kids, the students specifically, to be able to move on. That's very important.
So true. So what do you think is the importance of this restorative justice within the context of higher education?
It really allows, its purpose is, in a way, to be able to get the individuals involved to be able to move on. What in a, from a very difficult conflict. And it requires collaboration. That's the whole idea of restorative justice. It requires collaboration between the accuser and the accused. And what it does, I hope, is to be able to satisfy the accuser so that he or she is able to be restored from the harm that has occurred to them, and also to get the accused to understand what they did and why it's so harmful or hurtful. And so that they'll understand and receive the knowledge so that they can not just move on, but protective of them so that they know how to behave in the future. And also restorative justice is a way to bring everybody back to kind of a pre-harm level. And so that they can continue with their lives in a good and healthy and fruitful, fulfilling way.
I think we all kind of understand and anticipate some changes to Title IX federal regulations. So how would you suggest schools ensure due process, all amongst the possibility of a live hearing requirement being abolished and removed?
Well, I'm not so sure the live hearing requirement is going to be abolished so quickly, because it's not just the Department of Education that's involved, or the Office for Civil Rights, it's also the courts. And what we're seeing, and have been seeing for a while now, is that courts are imposing a hearing requirement. The single investigator model is not, creates a problem for the school, because then the individual who have been expelled or suspended or expelled, in other words, their education totally disrupted, has the ability to seek relief in court. So I'm not sure that the hearing requirement, especially where credibility is involved, and it's mostly those cases where the courts have been reluctant to let the schools continue with the single investigator model. Those cases will probably still be a hearing, even if the Department of Education, the Office for Civil Rights, changes or takes away the live hearing requirement. It's interesting that they may do something short of that. In other words, maybe it won't be asking questions, still have a live hearing, but you won't have lawyers necessarily being the ones to question the accused and the accuser. Rather, you'll have what we had in the past when I was doing hearings. They presented me with questions. Each side would present me with questions, and I would ask the questions of either the party involved or the witness, if it was a witness. So we'll see what happens, but I wouldn't count out live hearings so quickly, is what I'm saying.
If you had to do it in just a few sentences, how would you best describe the overall benefits of using an experienced mediator or hearing officer for Title IX proceedings?
I've written on the idea of mediation, presenting mediation into the Title IX structure. Informal resolution is permitted now, and it can be done through an experienced mediator, which is the way to go, because experienced mediators know how to empower, I would say, the individuals involved to make the decision themselves of how they want, where they want the resolution to end up, or how to empower them to resolve their own conflict. And experienced mediators know how to do that. We've been doing it for ages. It's very powerful. It's very, especially for students, it's empowering, and it advances the educational mission of the school besides, without having a win-lose situation going on. That's really a better way to go, I think, in these cases.
Well, thank you very much, Judge, for joining us today. I really enjoyed to get to know you a little better, and thank you especially for sharing all of your insights and your thoughts on that very important Title IX work you do here for us.
I was delighted to do it anytime.